you need to understand that when you're using a mortgage to purchase a property, there are two transactions. There's the conveyance and then there is the mortgage. And it is oftentimes in your best interest to do your conveyance yourself and then do your mortgage. All right? Now, because the reason I'm saying that is, remember, you will be using the bank's attorneys who are not your attorneys. They do not have an obligation to you. You are not their client. Their client is the banks. And this is something that a lot of first-time buyers get very confused about. So if you all are still confused in the listening audience, ask me any question, because we've had several matters. Justice Frank 𝗙𝗶 made a very powerful judgment against this in 2021, where he reiterated that in our culture, it is a norm that this great conflict of interest happen, where certain financial institutions even insist that you must do their conveyance with their bank. You have a right to go against that. They cannot bully you into doing that. And once you qualify for a mortgage, they cannot say, well, you are disqualified by virtue of you wanting to execute, to do your own deed of conveyance. All right? You could actually sue them for that. All right?
Great.
So that's one thing in terms of a purchaser knowing their rights. So you have the right of disclosure. You have the right of independent legal counsel. You have the right to do your due diligence and your searches, because any encumbrance you purchase, you're stuck with it for life. It's going to be a you problem. So it's very important that you do your due diligence, because every conveyancing transaction is governed by a legal principle called 𝗩𝗶�58𝗪𝗀, which is buyer beware. So it is an automatic assumption that the buyer would have taken their relevant due diligence, right, in order to do the necessary title searches to do it. I have seen many first-time purchasers be so anxious and so emotive that they get frustrated and waiting for title searches. They want it now. Never rush a title search. Dig and dig and dig. If it takes you 3 months and you have the time in your sale agreement, you do it.
Is that why, and I just about to talk about sale agreements, is that why a sale agreement takes this amount of time? Because, you know, I've purchased property before and they tell me after 6 months, 9 months, 8 months for the sale agreement. And so I want to understand, what should that time, or what does that time afford me to do, or what should I be doing in such time?
It affords a safe space for the purchaser to do all their due diligence and, you know, really mentally get themselves acclimatized and be in a safe space and securely make a decision in relation to the purchase without the fear of it going to another buyer. So you're actually going to keep the vendor obligated to keep the property for you within that specific period of time. And then you can unearth anything. You can get some more time to get your money organized. You could probably change banks for your mortgage because you get a different, you know, a better deal at a better interest rate. You do all that time to do your shopping around and take your time. First time purchasers, you all should never ever rush a conveyancing transaction. Buying a property is a big deal. This is not a small purchase. If you are mortgaging, you're entering a very long-term relationship with this financial institution, and you are making a lifelong purchase. A property is not something that you part with easily. Why would you want to rush that down into 6 weeks for something to stay with you for 60 years? I don't.
Got a deal good. The deal is good. I get any property for half the price. I mean, it's a good deal, and I'm a little facetious there because I want us to understand. I want to ask the question, Ms. Daniel. What are some of the hiccups, some of the pitfalls? As one audience member said, what are the red flags? So many things we need to look for. Before Ms. Daniel goes, there are physical red flags or infrastructure red flags, which I will go through as well. But go ahead, Ms. Daniel, on the legal side.
Okay, so legal red flags are Number one, the vendor has no physical copy of the deed. That's your number one red flag. They say it registered and they want you to obtain a copy via a title search, and they themselves do not have a copy. Second red flag is that the document in their hand is not in their name, it's in somebody else's name, and that person not there, and they're saying it's, you're doing it for them, that kind of thing. That's a huge red flag. If the person selling you the land, the property is not in their name. It may be that it is in a deceased person's name, and they are telling you that you're waiting for the probate process, which we know has an indefinite period, and it is your choice to purchase something such as that, but that is an encumbrance, right? So for me, the least comfortable I would be in is when the party who is selling doesn't outrightly own. That's a number one red flag. It doesn't mean that the transaction is impossible. It just means that it is a little more convoluted and complicated to make sure that everything is well done. Yeah, right? Another red flag is that there aren't any approvals. Many times persons sell property a lot lower than the market value because no approvals. But there's no approvals and there's no approvals.
Yeah, and I get sick a little bit.
Right, which Mr. Paul will get into in terms of infrastructurally. How bad is the non-approval? So for instance, today a client contacted me. He just was like, I want this, that, and the other. And he listed up. I just want an invoice. Just give me a quotation. He don't want an initial consultation. This is what he wants, and he wants a quote for that. And he don't know why we want to meet with him. I said, sir, that's a very important point. Different zones in Trinidad and Tobago has different municipalities and different regional corporations, and each, and Mr. Paul will talk about this civil engineerily or infrastructurally, there are different statutory requirements that constitute approvals for lands based on where the lands are. You cannot just hear your friend in the rum shop say that he bought lands in Grandy and he needed X, Y, and Z, and you buying lands in Superior and you need the same thing. It does not work like that. Where the lands are very much vary in terms of what the statutory requirements and what constitutes as approvals are. Grandy Regional Corporation requires lights. They don't want water alone. Why? Because many years Grandy is notorious for giving a lot of town and country approvals in very badly developed lands, and many persons sued the regional corporation after a while when they purchased property and it was so destroyed, right, by lack of infrastructure, that they have become more stringent than, let's say, a REMA that is very heavily developed, and it is kind of obvious that you will get lights in most of those areas. So you have rural areas that will be a little more stringent. And then we have, when you have property in Rosalak, right? They are obsessed with drainage. You know that because they flood. So every area in Trinidad and Tobago, based on the infrastructural climate, right, and the quality of the area, approvals look differently. And you may be able to purchase a piece of land with no approvals in a less rural area and have way less problems than a very rural area. So no approvals in a very rural area is a very different story from a more urban area. And so you must understand, when you're buying agricultural land and they literally tell you as the vendor there are no approvals, you need to count the cost of what you are getting yourself into, because you are buying the problem from the vendor. And I am going to require to do a lot more for you to get the property in your hand legally, especially if the land is under the RPU. There's something I want you all to understand. It is not just like attorneys like to drag on the transaction, period. No. If your title is under the RPU and you have no approval, it is almost impossible for me to get you title. All right? or for me to subdivide easily, you need some sort of approvals for RPO lands. If it is old law, we have a little bit easier, all right? But statutory approvals critically affect conveyancing. And I am not one of those who will just give a client what they want up until the point where the client realizes this is not what they needed. Because you're going to blame the firm.
Right. Just to piggyback on what Mr. Daniel was talking about in terms of we say it all the time here, we call it DRUs, drains, roads, electricity, water, and sewage, right? These are the approvals that you are looking for. Is the house that you're buying approved by Town and Country? If it is not approved by Town and Country, why is it not approved by Town and Country is an important question, because again, there's houses that somebody built, they never get the Town and Country approval, but it is approvable, right? And then there are houses that you will buy that you are not good. Town and Country is not going to touch it with a 10-foot pole, right? And it's important to understand where you stand, because the value of your property drastically changes. The amount of consideration you pay for your property drastically changes when you have approvals versus when you do not have approvals. It can be up to 100% more.